Chair, and I just want to start off my call on this part two by foreshadowing two SOPs that Labor will be putting up in this part. And Mr Chair, it's important to say that Labor has put these SOPs up here in part two based on previous rulings in the ACC legislation about where these matters need to be raised. And the Chair previously ruled that expiry provisions must be within a part of the bill, not with the preliminary provisions. So we are following that ruling, Mr Chair, and these amendments are to be inserted as a new clause in Part 2. The two amendments are very different. The first one is an amendment to expire the entire Act in a sunset clause, and the second amendment is to expire only Part 2 of this piece of legislation. I very much look forward to the ACT Party's support for these SOPs, as the ACT Party has regularly called for legislation and regulations to have sunset clauses and expiry dates. In this instance, we agree with them, and we look forward to having the majority in this House for passing these sunset clauses, Mr Chair. And when it comes to Part 2, I do urge the Minister and the Chair to answer some of the questions that are going unanswered in this debate. And I, for myself, would really appreciate some clarification over the compulsion in the taking of DNA samples from minors, because I have the Criminal Investigations Bodily Samples Act 1995 here in front of me, which is the principal act which is being amended in this part, Mr Chair. And what the reading of that act would imply that you can compulsorily take a sample from a 12 or 13-year-old in the case of murder or manslaughter, and my reading of that is that this amendment to the Principal Act that the Minister is putting forward in Part 2 will extend that to any indictable offence of 14 years or more. And I'd like a clarification on that what we're doing here is saying that a DNA sample can be taken compulsorily from a 12 or 13-year-old for any indictable offence of 14 years or over. And I don't think it's too much to ask that we just have that clarification so we know what we're actually passing here this evening. And this is of particular interest to me because I gave many speeches on previous legislation amending the Criminal Investigations Bodily Samples legislation that this government passed, which extended the DNA database. And the reason that I did that is because while I'm a great believer in DNA legislation, I'm a great believer in its potential not just for convicting, but for freeing those people who have been innocently convicted of crimes. It does worry me that members of this House don't seem to realise that while this technology has enormous potential, it also has enormous risk and restrictions in its ability. It's not foolproof by any stretch of the imagination. And members of this House know how powerful DNA technology is. If you go into a courthouse, you're a 12 or 13-year-old, and you have DNA evidence against you, it's very difficult to argue out of that charge, Mr Chair. The fact is, all DNA evidence does is prove that your DNA was at the scene of a crime. That's all it proves. And it's up to the rest of the evidence to come around that and prove why your DNA was there, that you were there, and what you were doing while you were there. So this idea that somehow at a crime scene if you find someone's DNA it means they committed the crime, I find that worrying that we've had members of the government who have, in this legislation and in previous DNA legislation that we've passed, have made those claims. They've called DNA testing a fingerprint. Well, Mr Chair, it's not a fingerprint, because a fingerprint is an entire thing. When you come to DNA testing, you only tested a few loci. Something like 0.001% of your DNA is tested when you have a DNA sample. So while it's incredibly accurate, it's not a fingerprint. And if we're going to be extending, again, the use of this technology and the powers of this technology, I want to hear, and I'm pleased that the Justice Minister has come to the House, because I want to hear that they understand and that they are prepared to articulate not just the potentials but the limitations of this technology. Because as my colleague Leanne Dalzell has pointed out time and time again, it's not just that it's difficult to exonerate yourself if you're innocent and you have DNA evidence against you, it's that it's hard to get a conviction sometimes if you don't have DNA evidence used, because people believe, because they watch CSI, that DNA is always in every single case. It's called the CSI effect amongst the science community, that DNA is always there in every single case. Mr Chair. Thank you very much, Mr Chair. That DNA evidence is there in every single case, and if it is there, you're guilty, and if it's not there, you must be innocent. Well, that's not true. And when we have legislation, and with the greatest respect to the Minister and the Chair, I would like a comment on this. When we keep extending the jurisdiction of this technology, I want to know that the government understands those limitations. And I really would like the Minister to stand up and explain exactly, say categorically yes. This is about the compulsory taking of DNA samples from 12 and 13-year-olds for any indictable offence 14 years or more, and that's been extended for murder and manslaughter. Because that's actually why we have committee stages in this House. It is the one opportunity that we have on legislation for opposition MPs to put questions directly to a minister and to have them answered, particularly on legislation which is of such importance, Mr Chair. And I sincerely hope, because my colleagues have told me that this question hasn't been answered, that the Minister is prepared to answer that question and to clarify that not just for members on this side of the House, but for the public of New Zealand who want to know exactly what is being passed into law here, Mr Chair. And I'm very pleased to see the Minister seeking advice, and I hope that we can get some clarification on this point so we can stop asking the same question. But until we get a response, Mr Chair, I think it's very, very unfair of the Minister to just not answer our question and then have closure, as the government will inevitably try to do, without answering that question. Because previous members have said we are talking about children here, and we are. I mean, these are 12 and 13-year-olds. And I think anyone who has children, or anyone who was a 12 or 13-year-old, knows that we are talking about children. And it's terrible when children do tragic, awful things. But I would also say that the taking of a DNA sample is prior to someone being found guilty. And we do actually have innocent until proven guilty in this country. So when we're talking about extending the jurisdiction of this technology, which is very powerful but also comes with enormous risk, we have to remind ourselves that when we get tub-thumping speeches, chest-beating speeches from the government about how they're tough on crime and they're cracking down on these terrible, awful, these tiny horrors and terrors, that we do actually have innocent until proven guilty in this country. Just because you have a DNA sample taken doesn't mean that you're guilty. Doesn't mean that you're guilty. And I think, given the extension of these provisions, the extension of this jurisdiction to people who are 12 and 13 years old, who may well not have done anything wrong, I don't think it's too much to ask that the Minister and the Chair takes a call and clarifies for the opposition members and for the people of New Zealand exactly what we're passing into law here, because it is not clear. And I would also like the Minister, in her response to that question, to acknowledge that the government, despite all the speeches they give on this, understands the limitations of this technology, are going to fund ESR, who do the DNA testing, through a contract with the police, are going to fund ESR properly, are going to train police properly, because in Victoria they had to hire special squads to forcibly take DNA samples from minors. Forcibly take them. They had to be trained and had to hold them down to forcibly take a DNA sample. So I want the Minister to clarify that may well be what we're talking about here. And if it is the training going to happen so that we don't end up with endless police complaints authority complaints going in, endless court cases and litigation over what police can and can't do? Because the police need protection in this as well, about exactly what they can and can't do to forcibly take a DNA sample, because we are extending this well beyond where the current law is at right now, well beyond where it's currently at right now. But more importantly, will ESR be properly funded, not just for the cost of doing a single extra DNA test times the number they think they're going to do, but for the administrative staff who need to receive the samples, log them in correctly, continue the chain of custody that started with the police, ensure that we don't have any miscarriages of justice because of lack of funding for those administrative functions that ESR carries out. And this isn't scaremongering. This has happened in other jurisdictions. In fact, the murder, so couldn't possibly have done it.
The Honourable Leanne Dalzell.
Mr